this is a huge topic. It is, we've been talking about it, I suppose, well, it's going on for many years, but it has really come to light since about a year and a half ago and 2 budgets back. It's causing an awful lot of farmers a lot of issues, and the fear of what could be coming down the line from a tax point of view is absolutely penal and crippling and frightening for many, many farmers. So, I mean, we completely understand that there's a housing need, and at the same time, we're getting increasing calls from very concerned farm families about this residential zoned land tax. So I suppose our main concerns are that ultimately genuine farmers must be protected and exempt from this land hoarding tax, as in the vacant site levy in the past, where land that was farmed was exempt. So any tax or policy needs to be fair and transparent. I mean, at the moment, it discriminates against the genuine active farmer. So there seems to be no transparency in this residential zone land tax that has been brought in. And there's a huge lack of awareness out there regarding the tax and the local authority inconsistencies. Because I suppose the way the legislation has been designed, the authorities just had to publish the maps. There's no requirement on them to have to notify people. So that's a huge issue. And farmers wouldn't actually have gone looking for the zoning in the first place in many cases. All they want to do is farm their land that they have in their family for several generations. So, I mean, non-action regarding this zoning will lead to no action on submissions, and therefore there will be a significant charge on the land. And basically what they're saying is that, I mean, if somebody doesn't know about it, doesn't make a submission to get their lands dezoned or the zoning changed, then because this tax is a self-assessing, the onus is put on the farmer to make the submission themselves and make the tax return. And then if that's not done, and there's taxes, interest and penalties on it, that if it comes to, I think it's 110% of the value of the lands, then they can be, we'll say, taken in charge by the department. And that's not right either. So the submission deadlines are far too tight. We have made this in our campaign, made this point in our campaign over and over again, but there has been no move on any of the deadlines so far. You're probably well aware that the first deadline there to make a submission to the council was for the last day of December. And now the council had to come back with their determinations to people by the 1st of April. And the next deadline, if people are still not happy with the determination or the results that they got from the council, then the next deadline is the 1st of May to make a submission to An Bord Pleanála. So I suppose that's where we find ourselves today, that with Easter in that time frame, it has taken a week or 10 days out of the month. And farmers who are impacted by this or in scope for this tax need to make a submission to An Bord Pleanála. So, I mean, we would say that it is completely unfair, and that in some areas where land has been zoned, there may not actually be a housing need in that area, or there may be other brownfield sites that can be used first. This tax at 3% of market value is extremely penal. It's disproportionate to the income that's actually being generated on many of those farms at the moment. So on that basis, I'm going to ask our staff, Karol, and to Shane and to James Staines, that we have a presentation that we're going to put up online, and we'll take questions as the webinar goes ahead. But we'll go ahead with the presentations first. Thank you.
You see that there, Rosemary?
Yes, can see it now, and I can hear you too, Shane. So fine,
Right.
work away.
Thanks very much. Look, good morning, everybody. As Rosemary probably touched on a number of items probably that we were going to have a look this morning, but very quickly, I suppose there's three key takeaway messages that I just like you to take with. And the first of all is, as Rosemary said, look, at IFA have done a significant amount of campaigning and lobbying around this, and it's very much a priority for us to ensure that we get farmland exempt from the zone land tax. As Rosemary said, there is precedent there in other forms of previous legislation that could be utilised if there's political will, and certainly we'll be expressing among all politicians and local councillors, etc., to ensure that happens. We're also, I suppose, and James is on the call there as well, engaging in getting senior council's view in terms of where we stand on this, particularly from a constitutional ground, but see is there any angle that we can work on to get farmers exempt from it. I suppose that's from the IFA perspective, and as I said, we will certainly push as much as we can from your own perspective as individual farmers. You will have to follow the kind of process or the train, if you like, in terms of what's outlined within the existing Finance Act under the Zone Residential Land Tax. And at this point in time, the next deadline, as Rosemary said, is the 1st of May. From two perspectives, first of all, really is in terms of for a lot of farmers who unfortunately didn't get their desired outcome on that submission for the tail end of last year, you have until the 1st of May to get your submission into An Bord Pleanála, again challenging that determination. So that's the first thing. The other item is that there's going to be supplemental maps published by the local authorities on May the 1st as well. So again, from that point in time, it's important that all farmers with land in the hinterlands on towns and villages look at that, see have you land under scope for the zone residential land tax. But also farmers who, whether are in the vast minority, who they were successful in their appeals to the local authority, they should also look at the maps to ensure that their land has actually been taken and excluded from the map. So there's a 4-week window there from the 1st of May until the 1st of June to put in your appeals again, to follow the same process than what has happened at the tail end of last year. So look at, I suppose, and again, there are the three takeaway messages. IFA, this is very much a priority for us, and we're going to do everything within our power and remit to get farmland exempt. But from your own perspective, May the 1st is the deadline in terms of getting your submissions into An Bord Pleanála, and also, check the supplemental maps to make sure you're off the maps. So just very quickly, in terms of a quick recap before maybe I hand it over to Karol, to look at in terms of some practical information and advice in terms of pulling together some submissions. So as Rosemary said, this is a new tax being introduced, coming into force from 2024, a 3% annual market value tax introduced under the Finance Act, and it will replace the vacant site levy. One key difference here is that outside of farmland now being in scope for the tax, previously the vacant site levy was administered from the local authority. This is a whole new ball game in terms of the revenue commissioners is going to take on the administration of it. So look at, they take things very much black and white. So there's lack of flexibility in many respects when it gets to the revenue commissioner. So now, while it is frustrating that you may not be seen to get the inroads that you might desire, now is a chance really to influence change, before it gets to revenue commissioners. And again, May the 1st is that important deadline. So it be included in under the scope for the tax. The land must be zone residential. It must be serviced in that they must either have connection to or in proximity to roads, pathways, lighting, water, and services in terms of drainage from both surface water and sewers. It also has to have service capacity and also be suitable for development in that it's not prone for flooding, or there's no item of archaeological importance on the site that may prehinder or the actual development taking place. Now, there are a number of kind of ambiguity, if you like, in terms of the lack of clarity in terms of what constitutes service, and in particular what constitutes service capacity. You may have access to services on the boundary of your plot, for example, which may tick that box, but if it only is enough to cater for one house, is very different than a site that may be able to cater for 100,000. But there's no definition currently within the legislation on service capacity, and that creates its own issues to some extent. There are a number of exclusions in terms of from the zone residential land tax, and certainly residential property or gardens are excluded. They may be highlighted in the maps. If your kind of cutilage is above 1 acre in size, you do need to register on the zone land tax register, but you're not necessarily liable for it. But that's just something to note. Effectively, any businesses that are liable for commercial rates are also exempt from the zone land tax, as is land that's zoned mixed use, including residential, where the land is deemed integral to the business and is not deemed vacant or idle. And look, I suppose from a small number of farmers who were fortunate in many respects to have their land zoned mixed use, you know, that certainly is a ground that a number of them did happen to get success on in the previous submission. And if you do find that maybe you didn't state that in your initial submission, if your land is zoned mixed use, and again, just for someone that doesn't know, if you go back on the maps, if it's the red coloration, that was the mixed use. So if your land happens to be coloured red, you can bring that forward as a point of challenge in terms of your inclusion. Other items there, there's a number of kind of infrastructure items in terms of the provision of utilities and services for communities that are exempt from it, as is land that's currently subject to the derelict site levy. And as I touched on previously, anything that's prone for flooding or has something of historical importance is also excluded. But I suppose, you know, and again, I can't reiterate this strongly enough, is that, you know, IFA very much understand that there is a housing challenge out there at a national level. We understand the sentiment of the zone land tax, but, you know, really we strongly oppose the inclusion of farmland within its inclusion. And, you know, when you stand back and look at it objectively, you know, naturally we're going to come here from an IFA perspective, very much on the farmer members' perspective. But when you look at it objectively, it's very hard to stand over a taxation instrument that's been introduced to tackle a housing crisis, and yet housing need or demand isn't built into its design at all. And I think that's a fundamental flaw with this tax in many respects. The other kind of things that are working against the farmer, as Rosemary touched on, is that, you know, there's no account taken of purpose or intent on the farmer, and there's a significant portion of farmers out there that never actively sought to have their land zoned in first instance. You know, a local, the authority in the development of the county development plan quantified X by way of you know, future need. They drew a circle around that area, and that land was zoned. So there's many farmers out there that are currently farming away that have zone status on their land that don't actually know that. And as Rosemary touched on earlier on, the legislative doesn't actively require the local authority to directly engage with the landowner. They only have to put up in the local press or that the availability of the maps that are in the local offices or online. So like that lack of direct engagement with potentially impacted farmers will create significant problems down the road, under no doubt. As I said, one of the biggest flaw on the design of the taxation is that it doesn't take into account housing need or commercial demand. And I suppose that brings into question that we maybe get a number of times, since if there's land that even if it is zoned, you know, and there's no commercial demand or housing need, what impact does that have in terms of the valuation? And again, that comes around in terms of the self-evaluation piece, in terms of which the zone land tax is falling under place. But, you know, certainly from what we would be suggesting, and look, that's down the road if need be, you know, farmers at that point in time, you know, it would be worth getting professional evaluation. And if they put, you know, your land at agricultural rate or even below agricultural rate, given to some extent the designation of the zone land tax on it, if you have verifiable evidence there, that at least you have something to stand over. But personally, I would be very reluctant to go in overly low initially without that kind of credible certification against it, because there is, you know, penalties for undervaluation as well. As Rosemary touched on, the 3% market value is completely disproportionate to the actual potential income yield that can be gained from the land itself, and we will slide in a second just to demonstrate the stark nature of that in many respects. And look at the other element on it, and it probably is even amplified, I suppose, more recently in terms of the potential introduction of the land sharing value tax, is a significant evidence of overzoning in some regions versus the housing need. And look at one area that just maybe where it's a little bit particularly stark is in Tipperary, for example, and this data is taken from the Office of Planning and Regulation submissions in relation to the county development plan. You know, Nina, for example, currently has 86 hectares zoned residential, where there's only a housing need in the short term for 33 hectares. I see Clonmel is nearly double what it actually needs. Rossgrey, you know, is to a factor of 3. and even Thurles. So they're, significant towns, significant amount of agricultural farmland around the hinterlands that's going to be pulled into this zoned land tax, and farmers incur significant liability when there's no housing need in them areas. And then, really multiple perspectives from, and irrespective of what governments say that this is not a revenue generation instrument, when you take all them factors into consideration, it's hard to say it's anything but a revenue generation instrument. And really, from a farmer perspective, it's very much a land grabbing exercise to accumulate additional land bank for themselves for a housing need that they may need in significant years' time. But it's anything but fair and proportional, and certainly on the part of the farmer, as Rosemary said, it's very penal. And just to demonstrate that, what we have done here is taking the average farm income, and now this is on a per acre basis from the Teagasc National Farm Survey for the last 3 years. So you can see the average return that can be yielded on an acre basis across the different sectors there. We looked at, just myhome.ie, which is on the website, which documents available land parcels that were zoned for development purposes, and excluding kind of Dublin area, because look, at Dublin can yield prices multiples of what can be garnished elsewhere. But just to give some flavour of perspective, we pulled a sample of 62 kind of areas excluding Dublin and single dwelling house that were zoned and residential, and the average per acre price where it was listed in terms of an asking price was 87,500 per acre. Where you apply your 3% rate onto that, you can see you're talking an annual liability, 2,500 per year per acre. Now, like as I said, it's very, very stark when you think about it's 5 times in excess of the most financially lucrative, sector here. You're talking 20 times higher than what your suckler farmer typically can yield, 15 times higher than what anyone in terms of cattle finishing or other cattle enterprises, and 16.5 times your sheep enterprise, and 10 times on the tillage side. So, no one can argue that this is disproportionate and penal on farmers that will force land sale, because farmers just won't. The majority of them, are yielding relatively low returns at the best of time before the zone land tax come in. So this really is going to be penal on them, and to some extent the previous graph, people can argue in terms of, okay, it's a relatively small sample and whatever the case may be, but the stark nature of it is it's hypothetical in many respects, based on figures, okay, but these are real cases of farmers that we have been in contact with over the last number of weeks. And as Rosemary said, we're getting a serious number of calls on these regularly. And you can see, the potential annual liability that this zone land tax is going to bring on the individual farm holdings. Across the board, I'm not sure too many farms are going to be able to yield any liability there. You can see there in Kerry, there's 2 individual farms with an annual potential liability north of 100,000. You can see in Dungarvan there, 30,000. The individual farmer has over 50,000 for a farmer in Claremorris, and close on 80,000 for a farmer in Newcastle West. And again, that's based on our 87,500 an acre. As I said, it's on a sample from myhome.ie, and look, there may be some farmers there saying there's not a hope anyone is going to pay that for residential land in my area, and likewise there's going to be farmers around the country who say that's a very conservative figure, that I could get multiples of that. But I'm not putting it here to be reflective of cross-country kind of values. It just kind of is a figure that we have based on information to hand at this point in time. But even being somewhat conservative in some areas, somewhat excessive in other areas, no one can argue with the penal nature of it. And really, when you stand back, it's very hard to understand how a government are continuing to persist with this. They're all fundamentally going to force farm families out of a business and a home. It's very hard to see the common good in that. The other thing is in terms of equality, in terms of application, in terms of the cost of doing business. As I said, the commercial rates, any business currently liable for commercial rates is exempt from the zone land tax. But the actual application of the cost of doing business, if you like, for farmers here, for farmers that wish to continue farming, is very different than what is put on the plate for those that are for commercial rates. And on the commercial rates, it's typically equated as a rateable value of the property multiplied by an annual rate of valuation, and that fluctuates on an annual basis. But again, here it's just it's just a sample of 10 acres in Kerry, for example, and we applied the rental value. So I suppose the thing to note here is that your commercial rate is based on the rental value typically of the property, whereas the zone land tax is based on the asset value. So it's naturally going to be multiples on it. But for the same 10-acre kind of field, if you like, or parcel of land in Kerry, you can see the huge disparity in terms of the cost or annual cost that's going to be imposed on a farmer if they wish to continue farming with the residential zone land tax in comparison to what could have been. You're talking €800 in comparison to 26 odd thousand. So like it's very disproportionate, and as I said, also, you know, penal on farmers in terms of the methodology that's being applied here. So where we are now, and before I hand over to Karol, really, and Rosemary touched on, you know, this kind of train has left the station from the 1st of November last year when the draft maps were being issued. There was, you know, 1,600 odd submissions put in on the part of farmers by the deadline at the 1st of January. 210 of that was in terms of D-zone. And so the vast majority of farmers, you know, sought to challenge their inclusion on it, retaining the zone status on the land. The local authorities then had until the 1st of April to issue their determinations, and certainly based on the nature of the conversations we've had, the majority were unfortunately declined, and now that cohort have until the 1st of May to pursue with an appeal to An Bord Pleanála if they so wish. An Bord Pleanála then have 16 weeks to turn around their decision. For farmers, I suppose that and I suppose if farmers considering going down the judicial reviews, it's imperative that they do put in some form of an appeal to An Bord Pleanála by the 1st of May, because that's needed to activate subsequent elements of the judicial process. But for farmers potentially that missed the deadline of the 1st of January in terms of getting their challenge in terms of the inclusion of the zone land tax, they still have the opportunity to seek to have the land de-zoned with the local authority. Now, it's by no means simple or straightforward. It'll take a significant amount of local engagement and lobbying with the local councillors, because they fundamentally are responsible for either making the development plan in first instance or varying once it is agreed. So every 6 years, you know, there's a new county development plan. It has to be reviewed within 4 years, and it essentially sets the roadmap for the area in terms of the plan and infrastructural investment for that period of time. I've touched on it previously in terms of the Office of Planning Regulator, in terms of it's certainly worthwhile in terms of formulating your own submission, having a look at what submission was made in terms of your own local county development plan to see was there any anomalies identified from that exercise. So the Office of Planning Regulator, they kind of oversee the whole planning making process. So they review the individual county development plans to ensure it aligns with both regional and national policy. And they can identify, such as what I've alluded to previously, maybe excessive zoning relative to housing need. It may identify, you know, areas of flood risk. It may identify that are not addressed adequately in the county development plan. It may identify, you know, infrastructural need or assessment that are not adequately identified in it. So again, what I would be suggesting to any individual, and Karol, I'll hand it over to Karol here, but it's certainly have a look at your own individual area to see is there any kind of couple of facts or figures that you can pull from that to support your challenge in terms of the zone land tax, in terms of making your appeal to An Bord Pleanála. And again, the final piece for me is I just remind you in terms of the deadline of 1st of May, both in terms of getting your appeal into An Bord Pleanála and also to have a look at the supplemental map. So there may be lands that have been added to the map in terms of change zone status. You know, the local authority may be aware of land that had been or eligible for it, and since the draft map has been issued, and they're bringing it into the scope of it. So again, just keep an eye on that map to see where you stand. And again, the process is there. You have a month to issue your appeal and follow that process as well. So look, I'll hand you over to Karol there now, and he'll maybe provide some practical information in terms of pulling together your submission.
Thanks very much, Shane, and thanks very much, Rosemary. And like just before I start there, I'm just kind of going to go very quickly through the actual kind of the process of making your appeal to An Bord Pleanála. But just to reiterate again once more what Shane had said there, I think Rosemary as well earlier on, about how important it is that you actually do make this appeal, because as we're moving on to James Daines after myself to speak through from a legal perspective, if you ever have anything that you want to engage from a more legal perspective into the future, be that a judicial review, etc., you have to be able to show that you had tried to go through all the processes that were actually in place for you to appeal, be that the first appeal, that was there to the 1st of January this year, and now with Unbor Pleanála. So therefore, the most vital thing you can do this week, if you haven't done it yet, is to make sure to get that appeal into Unbor Pleanála. Now, I can't sit here and give you any promises that you will be successful, but it just means that you will have more options into the future by making that appeal. So it's vital that you do it. So as Shane had outlined there earlier, yeah, the deadline for the appeal is the 1st of May. And the reason is the 1st of May was that the initial decisions came out on the 1st of April, and it's roughly written into legislation with Unbor Pleanála that it is a month you get to appeal any decision to Unbor Pleanála. So therefore, get those appeals in this week. Now, I'm hearing little bits of chatter in the background, but I can't confirm that they may accept the appeals by email. Now, if we do get confirmation of that in the next couple of days, we will let everybody on this call know, and we'll put out a press release, or we'll put out some kind of a communication that people know that you do have the chance to get in by email. But I would at the moment try and concentrate if you can to get that written appeal and get it posted and get it in so it is received by the 1st of May by Unbor Pleanála. So when you are actually looking at the appeal, like what you must be focused on is on whether the land meets relevant criteria in the actual legislation, which is section 653B or not. So that's, is it zone residential, the service question that we covered there, or the chain covered earlier, the service capacity and the capability of development. So they're the kind of 4 or 5 areas that you need to be concentrating on when you are actually making your appeal. Like, so the sources of information that you will be including, or you should include on your appeal, is the actual grounds. So why are you making this appeal? What are the grounds? And I'll go through it in a bit more detail there in the next slide, what kind of grounds you would be looking at for the appeal. You need to be looking at what was actually said on the determination that you received, say at the 1st of April. So why was the appeal you made to the local authority? Why was that turned down? What kind of reasons did I give in that refusal letter that you did receive? And then any other additional information, the service of use of the land, which they may request. So usually with Unbor Pleanála, not usually, but sometimes with Unbor Pleanála, they may look at a case and they may decide that they need further information. So they may request further information from yourself, who has made the appeal. They may request further information to the local authority of why your land is owned, why it wasn't removed from it when you did appeal it, or there could be other stakeholders like the Department of Housing, etc., that, or anybody else who may have some kind of a stakeholder or some kind of something to do with whether this land should be or will be developed, say, into the future. So all these could be asked for further information as well from Unbor Pleanála. So when you do make the appeal, then there's 3 possible outcomes that you can get. The first one is, for want of a better way of putting it, you're just refused. Your appeal is refused. So what they're doing is they're actually confirming what the local authority have actually said, and they're in full agreement with them. The second one is that they actually say they completely grant your appeal and they overturn what the local authority said, which would be what you'd be hoping for. Or the third one is it can actually be a partial determination, so they can set aside maybe 1 or 2 of the parts of what you were refused on and may grant you leave and grant some of your appeal on some of the other parts that you appealed on. If you can go to the next slide there, please, Shane. So as I say, like what's kind of in the body and what you must be looking at, and how do you put the appeal together. So like on the grounds, you have to probably state at the start like that that you are challenging the local authority determination that you had received, and you need to put in the reasons why you are challenging that. Now, in many cases, it'll be different for different people, like, but we have gone through some things here in the calls, and I've talked to a lot of people, the same as Shane has even talked to more, and so has Rosemary, like the different kind of issues that are around the country. But like, I mean, it might be that you can recognise that, is there really a housing need? Is as Shane went through there, is there way more land actually zoned than will be required in the medium term in the area you're in? Even like the questions on services, it is written in the legislation about the services, but there's a bit of ambiguity there about exactly what's meant. Does it mean when it's serviced that the services are actually coming, let's say, into your field? Or is it that it's somewhere in close proximity, be that across the road or across a river or across a ditch, that it could come into your field? And also you've got the question you can look at there of, is there actually capabilities in the services that are provided in that town? So can the sewerage system actually handle, if your, say, 5-10 acres is developed and houses put on it, is there capabilities in that plant to actually take what be coming through? So these are kind of things you can look at it there for it. Now, I would say you need to be factual, like when Unbor Pleanála looking, they'll be looking at facts, like, so you need to be clear, and you need to state your position, and you need to state exactly as well what you're looking for. Are you looking for that your land to be D-zoned? Are you looking for it to be exempt from the tax? Or what exactly is the desired outcome you're looking for with your appeal that you're putting in? When you are putting in the appeal as well, you need to actually submit or to include probably either a submission of the reference of the determination for the local authority, or even better, if you can actually put in a copy of that letter with your appeal, it will help as well to put that in. The land parcel IDs and any other supporting documentation, they will also aid in your appeal, so you would include those as well. You can ask the council for a planner's report and prescribed report, and this will help identify how the local authority view the submission and the nature of information that was requested from third parties. So this is looking at how the actual local authority came to the decision to refuse your appeal that you made to them back at the end of last year, beginning of this year. So looking at that, maybe it will give you more grounds for how you will structure your appeal when you're making it. And then there's also, you need to look at, is there within the Office of the Planning Regulator submissions, local authority, county development plans that may support your case? Is there a lack of adequate infrastructure, like I was just mentioned there a minute ago? Can the sewer systems hold in it? Is it in a risk of a flooding zone? Is there a lot more of the land zones we were saying that actually will be needed? So all these things as well can be added to your appeal and included in it. But the number one message is that make sure that you put the appeal together, and that's kind of the structure of that. Now, reiterating what was here to start, like, I mean, we will be continuing to campaign, and there is a huge amount of work on the background on this to get farmland exempted. Now, there is meetings. We've had multiple meetings with the Department of Agriculture, the Department of Housing, the Department of Finance. Truthfully, we're not seeing a huge movement there. As Shane, I think, and maybe Rosemary outlined, it's political will that is needed to change this. So I would say to you, if you do have any interactions with your councillors or local TDs or any other representatives, make sure to keep speaking about this to them. Because if we think about it, you're looking at, let's say, the local elections are coming up next year, and there'll be a general election within the next maybe 18 months. So politicians are again starting to think about, let's say they're starting to think about getting re-elected. So therefore, any issue like this or any chance you have to meet with them, make sure that you mention the concern and the complete unfairness of the way that this tax is structured. Get your submission in. Now, it says if desired there, but I would be encouraging you, no matter what, get that submission into Bord Pleanála, because that just means that you will have more options as you move forward. So make sure to get that appeal in. And also, as Shane had said there, like, this is very, very important. And I think this could be forgot by some people, that we're concentrating on what the maps had said that were issued last autumn. But there's new supplementary maps coming from the 1st of May, and just make sure that you give a check of them to ensure that no extra land belonging to you is being included, or that any land that was excluded, if you were lucky enough to get some excluded from it, hasn't been re-included here. So just make sure that you check those maps. And I'll just mention there as well, as I say, we've had many meetings, and we've had many meetings with the Department of Housing and the Department of Finance, and I had requested for a representative from Housing and Finance to come on the call today, and unfortunately we don't have anybody, but I got an email back say when they weren't coming, so I'll just maybe read out very quickly the response I had got. So the response read, unfortunately it is not possible for officials from either department to attend the event. Determinations made by local authorities on submissions received during the public display period of the residential zone land tax draft maps have by now been issued to landowners. As the period for appeal to Bord Pleanála on these determinations is currently open, it would not be appropriate for officials from Department of Housing, Local Government and Heritage or Department of Finance to attend the webinar, as it may prejudice any assessment of appeals by Bord Pleanála. However, we are happy to continue engaging with you as the issues relating to residential zone land tax relating to residential zone land tax once the appeals window has passed. So that was a response that we got from the Department of Housing and the Department of Finance of how come they weren't on the call today. So unfortunately, they wouldn't come on it. But I would reiterate again, like this, we're having a lot of work we're doing in the background with these guys, with meeting them, with the Department of Agriculture to see if they can be at and push there, especially around the question of genuinely farm land. And the Department of Agriculture have confirmed to us that if there was a request from Revenue or Finance or Housing to identify land that is genuinely farmed, they have no problem in doing that, because if you think about it, they've got our herd numbers, They've got our single farm payment applications, they have other scheme applications, so they do have a record and they know exactly where the land is that is being farmed. So if that was something that ever could transpire, they have the ability to actually identify the land that is being farmed if we can ever get something to move there on a possible exemption list. And that's my take on this so far, and all questions are more than welcome as we move through the webinar, but I think we might hand over to James Staines now for his legal perspective. Thanks, Shane and Rosemary.
Karol, thank you very much for that. A lot of what I'm going to say, I think, is already to a degree being covered by Rosemary, Shane, and Karol and what they've had to say. So, this new regime was introduced by the Finance Act. So, to be honest, any changes we believe will probably need some form of legislative change, which will have to be done. The Finance Act usually tend to bring out each year at budget time. As has been mentioned there are a number of issues. We picked this up from day one, and I have to say, as these meetings have progressed and we've had various calls, and as IFA members have been in contact with Shane and Karol and Rosemary, other issues keep rising up from the very black and white way that this is set out in the legislation. Certainly, from day one, the definition of services has raised an issue, partly because the legislation quite clearly is different to what the guidance notes are saying. I've already seen slightly different interpretations around the country from different local authorities. So for some of them, for the service to be adjacent, they have to be literally over the ditch and you have to have access to them. For others, if they're nearby and you could get a way leave agreement across to them, they're taking that as a definition. And obviously, again, it's not just service, has to be roads, sewage, water, all that type of thing in terms of that. As Shane has stated, one aspect we're looking at is the capacity of services. I mean, what is, is there a service there? There may be all the services running past your gate, but simply the local authority will not allow you to tap into them because they're at full capacity in terms of that. So why should you be penalised when the local authority has failed to put in appropriate services? I know a big issue in this particular process has been the time frame process, because while the legislation had come out a year before, it was kind of, the train left the station very quickly, in that people were effectively notified, and as Rosemary pointed out, only in public papers. Landowners were not written to. Unfortunately, there is no obligation under the legislation for landowners to be written to, and publication in maps and putting up in the planning department, the local authority, or the libraries is deemed sufficient notice in terms of that. And I suspect that has caught out a few people, unfortunately. So that there is the timeline process. As this has gone on, we're finding again, what is residential zoning? I mean, and Shane has touched on that there in terms of the way the development plans, the conflict between the development plans and the views of the regulatory authority, you might say. So, and again, he gave the example there. I think it was Nina there, Shane, where there is an enormous amount of zoned land in comparison to the housing need. So, if I'm a farmer out the road, say a mile or two outside of town, realistic prospect of any land, of any houses being built in the next 10, 15, 20 years at all. But because of an over generous red line in the development plan, I'm being caught in terms of that. Then the question about how do there's no offers to buy it, and quite a number of people I've spoken to have said they've had zoning on their land for good or for ill, and they have never received a single approach from a developer, and they believe that their land is probably and realistically worth pure agricultural value. And certainly I know post crash, having zoning on your land did not add any value to it, and it's probably only in the last 2 or 3 years where that nearly dreaded phrase hope value has started to come in, and we're seeing that. But it's still, in a lot of cases, it's not adding a huge amount of value to the land, and I think that needs to be taken into account. Shane has mentioned there about getting the valuations and the way that's dealt with. If you are putting valuations in, it's the revenue. See it very simply as what if you were to put a for sale sign outside your gate or outside a piece of land, and all things being equal, what would someone offer on that? And that's where you need to you need to engage a valuer to do that, or an auctioneer to do that, rather than do it yourself. Because if you get the valuations wrong, and albeit I'm jumping ahead quite a bit there, if you get the valuations wrong, there can be quite severe penalties and interest applied, because the revenue will have access to a phenomenal amount of data themselves as to the values of lands and similar parcels in the area that might be had. So you just need to, just a point to be aware of if it becomes an issue. One of the first things I was asked about in relation to this was the possible interference with your constitutional rights, which we see here, one of your property rights, your private unenumerated rights for property, and also your right to run a business in terms of this. Is this fair and proportionate? As Rosemary said, yes, there is a housing crisis there. But is it fair and proportionate what they're trying to achieve when you take everything into account along the way? Sorry, let's look at my notes here again. The other points, if you tried to get the land dezoned, which is one of your options, and they refuse to do it, it's very silent in the legislation as to what happens if you don't want this on your land. Maybe you didn't ask for it. I think it will be a factor as to what engagement did you have with this. I did speak with one farmer. To be fair, they had worked with the planners. They had engaged their own planner to have the land zoned, and I think, you know, if you're zoned and you're very adjacent to services, I think that's going to cause problems for some landowners. For other landowners where they may not have engaged and it just became a handy, you know, part of a red line exercise, I think that needs to be taken into account, particularly if we're going to look for a dezoning in terms of that. As Rosemary had mentioned at the onset, we have now been instructed by the IFA to get senior counsel's opinion on this, and we've written, and papers have gone to him, and I will follow up with a summary of the issues that have arisen out of this. And indeed, Shane, I think it was yesterday, the day before, over the weekend, he sent me a note with following a conversation which brought up a whole range of other issues. So council will be updated on that, and Shane, myself, and Karol and Rosemary will have a call with him before any view is finalised. Now, at the moment, we have to say the legislation is there. Therefore, until proven otherwise, it is lawful and it is constitutional. So, as Shane and Karol had said there, unfortunately, it would be prudent to continue with the process and engage with it, because if you don't do it, you may be ruling out one of your challenges to it on a judicial review in terms of that. Clearly, if it is found to be unconstitutional, ultimately, then it will be back to square one. But unfortunately, at this stage, since no decision has been made, no tax assessment has been made, there's nothing per se for you to challenge. And this, perhaps, I'm sure some of you have raised a question or considered it. You've probably heard Michael O'Flynn, the developer from Cork, Glen Veigh, a very large developer, and Cairn Home. So, I mean, three very large residential developers who've engaged with the process. None of them, as far as I'm aware, have taken legal proceedings to stage, because nothing has been set in stone yet. So no final decision has been made that they can challenge. But in the meantime, and again, I think Rosemary, you mentioned there yesterday, Michael O'Flynn down in Cork, he got quite a large number of sites removed from the zoning, though I still think there's 8 or 10 are still locked up in it. So what I would encourage you to do is to engage in a process, make that appeal from Bord Pleanála, even if it's only a short one. And I think Karol had said that they might be able to do it by email, the more the merrier. I saw there in the chat that someone had said that the closing day is a May bank holiday, but I just saw there, just posted it up. If the last date for you to receive an appeal is on a weekend, public holiday, or other day when the office is closed, on Bord Pleanála can receive your appeal by 5:30 p.m. on the next working day that the office is open. So you can, you know, the closing date is Tuesday, but ideally get it in before then. And ideally, Karol, if they can send it by email, that's better, because otherwise, really, it should be sent by registered post to avoid any rows as to when it arrives. Because if it arrives a minute after 5:30 on the day, they're entitled to refuse it, and you really have no comeback in terms of that. Karol, Shane and Rosemary, we had a short call on this yesterday, and a point did arise. If for example, your land may be caught up in this, but you didn't do anything about it in December, because it was a very short period of time, you weren't aware of it, only became aware of it in January, you had other issues at home, we think there might be no harm in even just lodging your objection to the local authority, and at least from paper there's a paper trail which showed that you tried to engage and tried to deal with it. I mean, ideally, in due course, and I think Karol has mentioned there, we have, we will have local elections coming up next year. You may have Oireachtas elections or Dáil elections in the meantime, I don't know. But it is certainly, if you keep contacting your local TEs and the local councillors, and this starts getting pushed up their agenda, there's a greater chance that maybe some form of pause might be put in it, or some ability, if you missed the boat, so to speak, or when the train left the station back at the end of December, that there may be another window, an opportunity for people to make another round of applications in terms of that, if that's the case. But I think it might be helpful if you have already put your application in to show that you tried and you did, but because the way the system was structured, you're unable to protect your rights and move it on. So as I said, the next step from us is obviously to update council, senior council, out of any points that come out of this. And again, every time we have one of these meetings, there's always another little piece of information, a little nugget that comes to light that makes what isn't a legislation a very black and white issue, less black and white, and that's where lawyers live, is in that grey area in between, to find the little gaps. So we'll push on with push senior council to have that meeting with us and to come up with a final opinion as to what the issues are and how to progress it. I have to say, if council comes back and was to say this is unconstitutional for whatever reason, or it's invalid, again, until I think a step is taken by, to move it on or make an assessment, I think then and only then you might be able to deal with it. Just one final point from the constitutionality point of view. I mean, the state is entitled to impose taxes on lands. There's no doubt about that. The argument I think the state will make is that by the state's actions, by rezoning the land, there has been an increase in the value of it. And given the housing crisis, if you don't use it, you lose it, or you pay a penalty on it. So I think on balance, if I'm to answer, yes, I think the state, in my view, are entitled to make this step. And I think the question is the process that they've done in it. Have they taken into account a whole range of issues that keep coming up? And is the process itself correct? And I think that's probably where we'll be best able to challenge this particular piece of legislation. So again, I know if there's any questions, we can take them there through Rosemary. Thanks.
You're on mute, sorry there, Rosemary.
Thank you. So James, thank you, James, thank you very much for that. And to Karol and Shane, thank you very much for the presentations and all the information. We'll take some questions now, but I suppose just even a short summary, the couple of points that we have is that we are still campaigning, we're still lobbying, we're still knocking on the doors of the politicians. And I think if all people that are affected, all farmers, lobby their local politicians, TDs, councillors, and we have to push it at all levels, from a political level, and at all the meetings we get the opportunity to meet with Department of Housing, Finance and Revenue, and drive the message home. So hands up. I see Alex Wilson.
Yes, thank you, Rosemary. I just wanted to make a practical kind of observation there. If anyone needs to examine the status of services in their area, Irish Water maintains 2 registers, and they operate a traffic light system, a register of water supply and a register of wastewater supply. And for every area in the country, you will see that there's a red or a green or an amber warning, and it will tell you what the deficiencies are. And I wouldn't assume for a minute that your county council will take any of that into account, because the council's attitude is we'll throw everything at this, and if you get stuck like a calf in the barbed wire, they don't care. So there's an attitude here of we'll throw everything at it, and anyone who gets caught by it, well and good. The other thing about it is there's been the presentation showed there was 210 submissions for unzoning. Do we know if a single piece of ground has been unzoned? Because I'm concerned that the time frame didn't even allow for it, and that there was never an intention to unzone land, because councils don't move that fast. They couldn't have presented it to the councillors and had it unzoned within the time frame. It's as if the legislation never really, it was a dog and pony show. It never really intended for the land to be unzoned. So I'd be interested in the opinion on that.
I'm not sure with you, Shane and Rosemary, but just on that point, Alex, I have heard of nobody who got their land dezoned. I've heard of a number of people who asked for it to be dezoned and removed from the tax, and they did get removed from the tax, but not dezoned. I personally have heard of nobody getting it dezoned.
It would have been removed on a technical.
One that was partially rezoned rather than full dezoned on the full parcel area. So say you had 10 acres, 4 was unzoned. That's the only one example I've had.
Yeah, I think there'd be a distinction even between being removed from the map. We had half of ours removed from the map, but that's not the same as actually taking the zoning off it, which if the other half we had requested it to be removed. So I don't think that there's even time frame. And discussing with councillors, nobody ever came to them to ask it to be unzoned. And my view would be that zoning is the preserve of county councillors. And we've put into our submission that the process is flawed because councillors who have the power for zoning and unzoning were never presented with the option. So that might be an interesting angle for anybody preparing their submissions to put in, is that we don't believe the process of modifying the plan has been even presented to the councillors for consideration.
Okay, I see another hand up there. Nigel.
Yeah, I wanted to, can you hear me?
Yes, I can. Go ahead, Nigel.
Yeah, I just wanted to make the point that it's not necessarily the advantage of us to get her land dezoned. I live in Carrick-on-Shannon and they're considering putting a bypass through my land. Now, I assume if they dezone my land is, the council will then pay me less money if they go ahead with a bypass through my land. So there are some of us caught in this situation where, we're stuck. Possibly there will be a bypass running through our land in the future, and by staying zoned, we will get more money from the council for that. But on the other hand, we're going to get stuck with this tax. So we're kind of caught in a 22. So we have to just be fighting for the fact that farm that's been actively farmed should be exempt from the tax, regardless of what way it's zoned. And the IFA needs to fight that very hard, I think. Okay, thank you.
Okay, thank you, Nigel.
Just to say that is the 100% position just on that, Nigel. That complete exemption for farmed land, integral part of the farm business is exempt. That's be under no illusion of any alternative approach. That's it in a nutshell.
Yeah, Kevin here. Listen, just thanks for this webinar. I'm caught in the position that the council have said that my land will not be taxed for the land zone tax, but they haven't. I look for the zoning, but they have told me they won't make that decision and do anything and look at that until June. Now I'm here in Karol, and the council here have made a total cock-up with the development plan, and that's why the big delay is. But when I got on to my local councillors, I got totally mixed messages. One said, no, you can do nothing until June. The others looked blankly at me, and I think only for the IFA and Karol telling me to go and put in the submission, I was going to wait because that's what the letter had said to me. So I think, like what Alex said, there's total confusion out there on the dezoning. And don't forget, it's the councillors will only make the dezoning because they're handed it to the planners, and they'll only do what the planners are telling them to do. I don't think the councillors will make the decision themselves to dezone. And unfortunately, where I am, I'm only a mile outside the town. I'm like the meat in the sandwich. The town and the development is going out behind me, and I'm caught in the middle. So I can't see myself being dezoned, even though I am going to fight this until the end to keep it, to try and get it dezoned, because like that, we knew nothing of this until only 2018. I think it was the first time that we discovered that our land was zoned. So I think we have a bigger fight on this dezoning than on the tax thing, because councillors are not going to go and do this. And as Alex said, the timelines just are crazy on this. Thank you.
Okay, do we see any other hands up there? Karol or
Yeah, the next hand up I see is Andy. If you want to unmute yourself, Andy.
Can you hear me, Rosemary?
Yeah, can hear you.
Yes, I can. Go ahead.
Hold on. Just one second.
Hello. I'm from Carndona and and I have 5 acres within the town boundaries, beside an inner leaf road. And my land is zoned opportunity site number 1. But the question is, I wouldn't be able to afford to pay the tax. My income is very low, and I farmed that land for its last 40 years. And another thing that's happened to me, the county council put across our roadway, they made it crossroads, and they left us with a development entrance of 3 meters and a footpath outside it. And under the county development plan, we were entitled to a 20 meter setback when they created a new entrance in their Leaf Road, when they went through with the new road. They gave us nothing, not even what they promised. They ignored all safety aspects on our entrance and everything else. So the land is bottlenecked. And to make it easier for other farmers, I give over half an acre towards road widening behind the bottleneck road. But when I made the appeal to the county council later on this year, the services are all in place. The sewers, water, everything's near hand. But the only thing that's not near hand is the roadway. It's bottlenecked. And I don't own the road between the park and the bottlenecking area. So I'm practically landlocked as well in Dublin, as far as getting out is concerned. But they've sold my land for tax. And I made an appeal now to Board Panola from that land, because 6 times the bottlenecking is done away. And the county council is partly responsible for bottlenecking the land. Because when they went through the inner leaf road, they didn't buy enough, compulsory purchase enough land to get a safe entrance into our farmland. There's 3 or 4 farmers down that road. Before they went through, we had a safe entrance because we went through from the March Road on down the laneway to our land then. Everyone has individual gates onto their farm and all. And under the county development plan, we were entitled to 20 metres setback, which goes some way to unlocking this landlocked land. And also I had a letter from the county engineer. I contacted Minister Patrick Oliver, and he was advising me to take a legal action, but I couldn't afford that. I'm only a small farmer. And anyway, he sent back a letter to Pat the Cope, and Pat the Cope sent me on the original letter stating that if I needed to develop the land, I would need to upgrade the laneway. At the moment, our laneway is only 3 meters wide. It's bottlenecked, but I opened up the road, and it shows up in the development plan behind the bottleneck. So I don't know what situation I'm in. I should be exempt from the tax because there's no fair tax on any farmland, and I farmed that land for 40 years. I'm ready now. But I don't know what. Even engineer, the senior engineer recognized that the land was landlocked. So I don't know what to do about that. I have made my appeal to Board Panola. I've already done that. Do I sit down?
Yeah. Okay, Rosemary.
Okay. Yeah, thank you. The line was very bad. It's quite difficult to hear all of the detail, and maybe we will try and get in contact with you afterwards, after the webinar, on more of the detail. But I mean, from what I hear from you, it's good that you've actually made the appeals to the council and to Board Panola. So, I mean, bottom line, keep in the process and stay within the process, and that will help again. as this materialises, and we'll see what happens down the road. Have another hand there, Karol.
Yeah, we've got PJ Jones.
Morning.
PJ, go ahead.
Thanks very much for taking it. I'm Secretary in our Fingal branch of IFA and work with IFA for years as market coordinator in fresh produce. We're in a precarious position out here in our county Dublin because we've the Minister for Housing out here. We are a horticultural hub for the country. I'll just give you, for instance, there is an IFA member out here, a farmer trying to do his best. He's working 3 acres with his 2 sons and with other subsequent land to feed a farm shop, which he was in trouble with on McDonagh in the beginning, but eventually got it because he was selling his own produce. Now he's in a situation, that's why I'm saying this is unconstitutional. Now he's in a situation that if this goes through, he'd have to pay 90,000 a year on 3 acres of ground that's feeding a farm shop that both himself and his 2 sons are deriving an income from. One of his sons is married, so it's knocking 2 families out, and he's going to have to pay 90,000 a year, which is crazy for 3 acres because that's what's been put on it. So in real terms, he's going to be forced to sell his own land and give up an enterprise which has been done for generations and depriving his 2 sons of a livelihood for the rest of their lives, plus his own. So you're knocking 3 families out because no way will they be able to pay 90,000 a year. And as simple or as complicated as that, there's just one, for instance, which bears to me. I went through constitutional law with casual trading a few years ago, and it's your democratic right to make a living in this country. So it's unconstitutional to close 3 families down. They're being penalised that it's 90,000 a year they're going to have to pay if this goes through, because that would be the valuation on it. So the 3 of them together would be getting less than 90,000 a year out of it as an income to live on. So therefore, in my opinion, I think that is unconstitutional. So if somebody could answer me that, I'd appreciate it.
James, would you like to take that point?
Yes, sorry, PJ, thanks for that.
Thank you.
PJ, I mean, your point is well made there. The impact this tax has on it, and yes, it is an interference with the property, with the constitutional rights that you have. And there's a number of constitutional rights that are affected. There's the right to earn a living, which is set out specifically in the Constitution. There's the right to own property, and then that's also bundled up in the unspecified rights. And there's a range of issues arising around that. As against that, the state is entitled to interfere with your property rights and interfere with your right to have a business. I mean, they can zone land, they can restrict land, they can impose restrictions on the hours that you work. So that it's not an absolute right, and it can be interfered. But as I said there earlier in the conversation, it is about balancing up. You know, the state will make the argument that they need to zone land to be pushed on and developed and encourage people to basically use or lose it. But at the same time, there has to be an element of proportionality in it, and that's one of the points that we have raised with Senior Counsel, and we'll be looking at in more detail. But I mean, there's a very good example of how this will very adversely impact not just upon one individual, but a whole, a whole family and a couple of generations. So we have taken that point on board, and it is with Council for comment. Okay.
Okay.
Thanks, Rosemary. Next up, we have Barry Nolan.
Okay.
Hello. Yeah.
Yes. Hi, Barry. Go ahead. Yeah.
Yeah.
Yes.
Hi, everyone. Thanks for setting up this meeting, everyone, today. But I suppose my main point is just like what the last caller said, was speaking there. The numbers in this are probably not huge in regards to the amount of farmers in the country, but the consequences are massive to each farmer because it's completely disproportionate tax to what a farm can earn. So like where like I know you're talking about paying the tax and valuations and stuff like that. Like we shouldn't even be speaking about that yet. We should be concentrating on getting this tax for farmers null and void, because in reality, it's an expense that a farmer is not able to afford, and what it's going to do is force land sales by farmers because they won't be able to afford the tax. So in reality, I know Shane was saying earlier on that the revenue said it's not a revenue creating exercise. And if it's not, like, what is it? It must be a land grabbing exercise by revenue or whoever. So Minister McGrath was in the Dáil last January, and he said that all active farmers wouldn't be liable for this tax. So I feel what he was saying there was very disingenuous, and he probably put everybody off the trail thinking that perhaps this is not going to go ahead now and they're listening to us. But evidently they're not, because essentially it's a sneaky tax in the way they're doing it, and they're trying to get it in underhanded, and they're not getting much opposition. So the few people, or the amount of people that are affected by it, need to get together, and politically we need to put pressure on our local politicians, our local TDs, our local councillors. And of the councillors and TDs I've spoken to, they're all, I suppose, they're all amazed and can't understand how this tax can be put on farmers and what it's going to do to us. But they're all talking and said, look, this can't happen. But that's no good, because if it gets through, we're in trouble.
Yeah, Barry, and on that, I'd say, yeah, go ahead.
Yeah, sorry, I just wanted to ask Shane that if it wasn't, if they said it's not a revenue creating exercise, what exactly is it supposed to do? Like on farmers?
Well, look, I hold my hand up, and I 100% agree with you. I think it's nothing but a revenue generation and nothing but a land grab exercise, the way it's currently designed. Their position, and as outlined in the local authority guideline document, is they're introducing this tax to increase the availability of zone service land for development to fulfil housing for all and minimise the housing crisis. And as Karol said, we're in regular engagement with housing, finance, etc. They can hear our cases, but 100 times out of 100, they round back to the housing crisis. And that's our challenge all the time. And we might as well just say it as it is, because, and it's very hard to challenge it in some respects, because we all know that there is a housing crisis. I suppose our flip back to that is that there isn't a housing crisis in every town and village around the country where farmers are going to be liable for this tax. But also, in terms of some of the information and document that we would have included in our slide deck, there's also sufficient amount of zoned land tax already in the system without new land being brought in. And, you know, as I said, fundamental issue for me with this tax is, if it is being introduced to solve the housing crisis, how come housing need isn't built into the design of the tax? Like, you're effectively designing for something that it's not being taken into consideration at all in its application, and that's fundamentally wrong from my perspective, both in terms of the liability, but also in terms of the appeals process as well, in that it's not taken into consideration as also. Just going back in terms of what you mentioned there in terms of Michael McGrath and all, and you're dead right, it kind of, we got a lot of calls afterwards from it, in terms of, you know, guys and females thought that it's fine, sure, I'm fine now, I don't need to make the submission, that it, where land is an integral part of the business, it's not coming into scope. What wasn't clear from the article, and the point of reference, was that what Mr. McGrath was referencing was mixed use land. And what was alluded to there was 100% correct in terms of mixed use land. Once the land is not vacant or idle, if it is an integral part of the business, you are excluded from the zone land tax. The problem for 99% of farmers is that their land is not zone mixed use, it's zone residential only. And that provision in terms of the exclusion doesn't extend to that cohort. Now, we've also made the point in terms of a couple of our submissions, in terms of, as I said, the precedent is there in terms of the vacant site levy, in terms of getting farmland, but that in and of itself, that exclusion is also a potential avenue that could be pursued, in terms of, just because your land is zoned residential, if it's an integral part of the business, exactly to your point, it also should be excluded once not deemed vacant and idle. And look, I think we're all of the view that land does need to be released, but the right land needs to be released. And certainly targeting privately owned land that is integral part of the farm business isn't within that remit. There are people out there that are hoarding land that should be released for development. And that's where the tax should be targeted at. But at the minute, this is a very blunt, broad stroke taxation measure, like to what many of the callers or commentators have said, will effectively just force farmers to sell it in probably a flooded market in many respects, because a lot of farmers are going to be in the same boat, in the same area. And then, as I said earlier on, the land value tax coming into play as well. Developers will know that if they activate the planning permission, that will potentially bring added liability. Now, that's not enforced at the minute, and that's important to illustrate that. But again, you're dampening a market and you're forcing the hand of individual farmers effectively to offload an asset that they don't want to offload. All they want to do is retain it for farming purposes. So, as we've said numerous times, our key remit at this point in time, and as you touched on earlier, is to get farmland exempt from it. But again, to be straight with you, we haven't got much of a bounce of a ball to date.
And Shane, I completely agree with that as well. That it is a kind of a land grabbing exercise and get land at a cheaper value. But unfortunately, whoever gets the land, and if they do develop whatever, that will never be passed on to the end consumer.
No, 100%. All they're doing is feather in their pockets. Yeah, agreed. Yeah. And fundamentally, like, you're dead right, it could actually, in the short term, this could actually further inflate house prices and actually create its own problem. So you're not only are you not solving a housing crisis, you're potentially adding to it short term.
So last thing, then, I think this political pressure is going to, and everybody needs to get onto their local TDs and councillors and whatever. We've a face group set up there, Farmers Against RZLT. So every little bit helps, I think. Thanks.
I'm sorry, can I just come in there, Rosemary? It's just one thing that just crossed my mind there, thinking about the appeals and that, is that back in January, the Department of Housing released figures that there's actually still 75 ghost estates in the country since the time of the crash. Now, they didn't release, they were supposed to, but they haven't released yet the locations of where those are. Now, just anybody on the call, if there's any of those in your locality, I would definitely be putting that in my appeal, because how can there be a housing need that they need your land if there is something that has started being developed already and hasn't been finished, and it's been sitting there for the last 15 years at this stage? So just a reminder, if there's anything like that in your area, I would include that on my appeal as well. And I think the next person up is Sean, I see here in front of us.
Hi, sir, how are you? So I was wondering, we inherited the land and availed of the agricultural relief. So if we're forced to sell then based on the fact that the farm wouldn't be viable, is there something that means you wouldn't be hit twice, or does that just mean you have to pay the clawback as well?
I can try there on that one. I know the technicalities on that one is that you have to retain your ownership of the land for 6 years after you inherit it. But there is a clause there as well. Let's say that if you did sell, I think it's somewhere between 18 months and 2 years, you have to actually replace what you sold to the same value. So I think that's the answer you get there. I know the practicalities of doing that in your own situation, I don't know what it'll be like, because I'm sure your farm might be one block, and if you end up having to sell 10 acres and you get whatever you get for it, let's say, we don't know what it'll be, whether it'll be the priced value or it might be a development value you get for it, but where are you going to get those 10 acres to replace the 10 that you sold as part of the block? It could be miles and miles away from your farm. So I mean, it could actually make your farm unviable that way. But that's the way that tax relief works, is that, yeah, you're supposed to retain ownership for 6 years after you inherit the land. But if you do sell it, you do have an opportunity to replace that land you sold to the same value. And if you do, you wouldn't get caught with having to repay the, agricultural relief you would have received when you were taking over the land.
Okay, perfect. Thanks.
The next up there, I think, is Thomas King.
Okay. Hello. Yes. Can you hear me?
We can. Yeah.
Yes,
Hello?
Thomas, go ahead.
Great. You might remember there back in 1985, the government of the day tried to bring in a farm tax bill. It was 10%. It was €10 per adjusted acre. Michael Kennedy gave a talk on it at the time, and the principles are still the same in relation to the current position we find now in relation to the residential zone land tax. Now, and Karol just answered my question there in relation to the agricultural relief. Now, in relation to the current situation with regard to the carbon release, has anybody made a calculation into the release of carbon from this 22,000 acres that could see a release, according to Dr. Gould, up to 1 million tons into the atmosphere? And will the government be coming back in order to recuperate this escape of carbon into the atmosphere and the loss of secretion from the same land when it is developed? Now, the minister said that the farmer is being incentivized to release land into the market, thereby he having to pay a tax. And today, the government are incentivizing the builders to build housing, in that they will be reducing the cost to them and they will be paying them for actually building these houses. The incentivization, there's two different interpretations taken on it. One is a tax on the farmer, and the other one is to incentivize, which would be the appropriate interpretation of incentivizing, to give somebody a tax break and let the land be brought to the market. Thank you, and I hope I made some kind of a point that he could understand. Thank you, and that's all I have to say now in relation to the voting.
Thanks very much, Thomas. Yes, we did. We got those. Next up, where is Andy back in Donegal? I think again he's got maybe a couple more people up there with a couple of points to make.
Okay, can you hear me?
Yes.
Yes. Okay, my name is Mary T. Sweeney. I'm an AIM2 rep here in Donegal, and just to say that Peter Devine is calling for this tax to be repealed and reconsidered, because it is completely unworkable. There's a few points that I did not hear made today that I would like to just bring onto the forum. One is in relation to strategic residential reserve land, that how can you be asked to pay tax from the legal point of view for strategic residential reserve lands when you're not allowed to build on it anyway at this time because of the phased nature of planning. The other point for the legal team is housing land availability surveys, which is a format used by the county council planners. They already had a technique, a process in the system to identify and phase zone land for development, for residential development, and yet this survey, this format that they have developed was set aside to bring in this tax. So that must raise questions. The next point I would like to make is in Donegal and in many other areas around the county, we have a lack of confidence in build material, and this again may be very important from the legal team, not just in the farmland, but in the housing structures that are implicated by this tax. There are many people around this county and in other counties around Ireland that have been affected by the mica or deleterious materials fiasco. And these quarries and this material for build quality is still not guaranteed, nor is it clarified by government the right to guarantee on the quality of build material that we're being provided with in Ireland. So if this was to proceed through the dial in its present format, then people are going to be forced to build to meet the restrictions of having to not pay the 3% annual tax on their land. If the material is of deleterious quality and is proven so subsequently, will the government give any indemnity towards builders or developers or landowners who have developed something for themselves or for their own family? We have incidences of farming structures being implicated and impacted by deleterious material that are crumbling here in Donegal, and I'm sure that is happening around the county as well. So that might be an aspect that should be highlighted strongly, that there's a lack of quality by government inbuilt materials constantly considered in Ireland at the moment, and that legislation should be reviewed before forcing this tax in on top of landowners, which includes the farming community. One other thing, and it was touched on, but I do want to go back to this. Why should the farming revenue generated to support farm families be of any less value to our government than revenue provided by other commercial enterprises? So, you know, that is a huge question that needs to be asked. And as I say, it is a poorly conceived and poorly communicated tax. And again, unless we, the small band of people on here today, get out and torture and harass the political representatives, they are the people that signed this off. And that is so important that we keep lobbying together. And any further information I have, I will pass to your IFA team locally and nationally. I've spoken to Shane as well, and we'll put that forward. Thank you.
Thank you very much. Some very good points made.
Thank you.
Do we have...
I think next up is Eve.
I just wanted to ask about if your land is zoned for mid-density housing, but is actively being farmed and it is held in the strategic land reserve, are you still liable to pay the tax? Because you can't build on it because it's in a land reserve. And the County Council in Sligo don't want to release it from a land reserve at the moment.
Karol, I'm happy to take that question. Eve,
Yeah.
That's a fair point. It actually ties in what Mary was saying in about situations in Donegal. And to be fair, Shane had raised this point in one of our last calls that there are other landowners who find themselves in that situation. So if you can't build, you're restricted in terms of that. So that is one of the points that we will be adding to our list of that's already gone to Senior Council on to deal with that, because it shows those inconsistencies between what it says in the legislation, which it's very black and white, and it doesn't take into account these range of issues such as land that's covered by these strategic reserves. So that is certainly it certainly casts some doubt or raises a grey area over what you can and cannot do. How can you be taxed for something that you can't sell or build or comply with?
Just maybe to add slightly to that, Eva, I suppose there's an inconsistency also in terms of the application within individual local authorities, or certainly from some of the feedback we would have got previously. So I suppose no more than what we've tried to maybe get the message across today, if your land is being identified on the map as being liable for the tax, if you have, make your appeal or submission, and include that within that point, because as you say, if you're prevented from undertaking development because it's in strategic reserve, certainly you shouldn't be liable for this tax. But as I said, there seems to be an inconsistency in whether land in strategic reserve has been included or excluded in terms of the initial maps that have been drawn up. So I just check that and follow due course as required.
Okay, thank you.
Next, we've got Robert Armitage.
So the situation I'm in here is we bought this farm in 1985 to add on to the home farm, and myself and my brother became partners thereafter. And in 2018, we borrowed the bones of €1 million to build a new milking parlour and increase our dairy herd, because we had young lads coming on and they had committed to farm. So admittedly, the land comes right into the village where I am. There is sewerage outside the wall and there is sufficient water because the water tower is built in the middle of our farm. But we had no intention, and the council, I suppose, had no reservation in giving us planning permission for the milking parlour. But we need sort of every acre we have to furnish the funds to pay it back. So I approached my local councillors and they said, oh, put in your appeal to the council. But in the same voice, he told me, he says, your lands will not be dezoned. So subsequently, I did get my registered letter back from the council telling me my appeal failed. And I just don't know where to go from here, really. Whether do I look for planning permission myself and then try sell sites? It's actually right at the back of my own dwelling house. I'd be looking out at it. Do I look for planning permission and sell individual sites? Because I certainly don't want a housing estate on it. That would help me to furnish to pay for the borrowings that we undertook. I wouldn't mind farming with 10 less cows if I had the most of that money paid. Now, I know you might think that sounds like an awful lot of money, but there was a hell of a lot of infrastructure, and it was a rotary parlour, and we went from 120 to 300 cows. So I'd say the way things have gone this year, would need every acre we have to help to repay those loans. That's all. What's the thoughts on looking for planning permission myself for the few acres that's in it to try and sell individual sites rather than let the council come in and put a big housing estate on it or something? Even though that's not what I want, I prefer not to have to sell it at all. Thank you.
Robert, I suppose it's very hard to be definitive in terms of offering guidance from your own perspective, and looking for all individual farmers. I suppose it's a business kind of choice, and to some extent it'll take a fair degree of consultation, both with your accountant in terms of the consequences, in terms of any tax liability from any sale or whatever. But certainly that is an avenue personally I probably hadn't considered a farmer undertaking on it. But look, I suppose it is very hard to be definitive and give you direct guidance on it, being straight, certainly on a call without knowing all the detail on it. I'm happy to follow up afterwards if you want to do it offline.
Thank you.
Thanks. We've got John Nolan wanted to come in again, I think.
Hello, Karol. Can you hear me?
Yeah.
Yes. We were meeting Jennifer Manane this morning, so sorry about that, and I apologise for being late. Look, the one thing that's coming out of all this is coming from the politicians, in particular Jennifer this morning, that now when the letters went out back in the end of March, you know, the politicians, in particular the rural ones, are being hit pretty hard on it. People are realising it now. And I can't remember one of your previous contributors was saying, where does it go from here? Like, number one, we have to keep at this. There's going to be a long battle, and but for God's sake, keep lobbying the TDs. That's important. And they don't like it. And she did say that she's beginning to get an awful lot of it, and other rural TDs as well. We also met yesterday, as I was talking to yourself, Karol, and Rosemary, with Pascal Donoghue, the Minister for Public Expenditure, was the Minister for Finance. So this is, his department, and we discussed other issues as in reliefs, but brought up the rezoned land tax as well, and this new legislation that's coming in terms of capturing or recouping betterment when land is zoned. And again, he made no promises. I don't think he's in a position to do that, but he is. All he said was he will be talking to Michael McGrath about it again, I think, in the next couple of days, and he is. Again, is to keep the word to the Pascal Donoghues and Michael McGraths in this world, in particular people down in Cork too. They're hearing a lot of this, and they need to hear. So all we can do is keep fighting it, But it's going to be a battle. But IFA are the only people that can fight, are in a position to fight it. So, to Rosemary and Karol and Shane, well done, and let's keep at it.
Very good, John. Yeah, and on the back of that, I just say there that, I mean, I know that when this came out first, and we were lobbying with the politicians, the answer they had back to us was that there was an option built into the legislation for farmers to dezone if they wanted, or to apply for the zoning status to be changed. And that was the political line they all had. And even up to just recently, that was the answer they gave us all the time, no matter, in all the lobbying we did, in the budget submission and on the budget lobbying sessions that we had with all the political parties. That's the answer you get. But I feel at this stage now, since those letters have come out and farmers who went for appeal didn't get the positive news that they were looking for, that's now at this stage, and I suppose this is what we've done. We need to up the heat on all the politicians. They need to understand and to realise that there are, family farms affected by this that will be put out of business. So, and that's what we're doing, I suppose, in working with people that are involved, trying to get the message out there and trying to make sure that the appeals go to Bord Pleanála. And there are plenty of people that are hearing about it for the first time, so that they need to make appeals as well. Have we anybody else there?
Yeah, we have Robbie who's waiting to come in there for a little while.
Robbie?
Yeah, I just wanted to, yeah, thanks. Can you hear me okay?
We can, yeah.
Yes,
yeah.
fine.
I thought to, we're looking at the moment at a 3% tax on land that's zoned. But there's also another issue, which is the land shared value, which is also coming in. Now, from a cynical point of view, I would say that the government are using the revenue commissioners to force farmers to sell land, which they'll then hit them with 30% of the increased value, which goes into their own pocket. And as a number of people have said already, the eventual house owner is not going to benefit from that. But I just wanted to see there's been a number of cases, a case up in Meath a number of years ago with Intel, where huge efforts were made to get a farmer to part with his land, which ultimately failed in the Supreme Court, as far as I can remember. How much I have this view that the land shared value tax has been brought in at the same time as this. I think that they're working in concert together. I think both taxes are being worked together. One, to force the farmer, the 3% tax to force the farmer to sell the land, so that the authority then can come in with a 30% plus a part 5 plus everything else. I was reading an article. They reckon that the local authority will get 52% of the value of the land between the land shared value, the part 5, and the contributions. So I just think that there's a bit of skullduggery going on here amongst a lot of people. I don't know whether they're deliberately doing this or whether it's just a coincidence, but there's a number of taxes coming at the same time on what they now on zoned land or eventually development land. And that's just really so I suppose my question is that has there been any thought given to any link in thinking between the various, between the local authorities, the 30% tax, the new 30% land shared value tax, and the revenue commissioner's 3% tax?
I suppose the first thing to note, Robbie, is I suppose the land or the windfall tax, as maybe it was previously known as, it's still running through the review process, is not in place currently. But you're right, there has to be some direct linkage to it. And if you're skeptical, as you say, it's a double hit certainly on farmers. And I suppose, indirectly, I suppose, in terms of the land value piece, in that, it only comes in the 30% differential between existing use and zone status only comes in the form of liability from when planning permission is obtained on the land. So like many farmers who sell it, if they haven't planned it, they won't directly impact on it, but indirectly they will, because the developer will know that it's coming down the tracks. And in terms of, to your previous point, in terms of the 3% zone land tax, and farmers, like what we've alluded to numerous times and from numerous contributions, that it's just unviable for many to retain that land. So both realities together, coupled with the fact, I suppose, in that to your point, that over half of the additional revenue generated from it will be got to the local authorities. You could question the slide also we had in terms of the volume of zone land relative to the housing need, and whether they're all filtering in together to certainly to the farmers' disadvantage. So look, it is something, we would have raised previously in terms of the Commission on Taxation and Welfare submission in the form of, IFA resistance to any form of taxation in terms of wealth, the windfall tax, etc., that we would have done previously. And I can certainly imagine we will be formulating a strong challenge in terms of the land value element of it too. But, you're right, 100%. They're all teeing in together, and in all eventuality, it's the farmer that's being hit and losing out on it.
Okay, thanks.
We have Alex wanting to come back in there again.
Yes, thank you. I just wanted to ask if the IFA would consider putting together a national grouping on this, because in any one branch, there might only be 2 or 3 people involved, and it's not maybe a priority within any individual branch. But for everybody that's on this call today, I see 78 people. This is their #1 priority for the foreseeable future. So I just think if it would make more sense that we try and create a national group, and ideally under the umbrella of the IFA. And look, I've made an offer previously to Shane there. If we needed to get everybody together, we can, get a facility. We've made an offer of Gowran Park if everyone wants to come, to get a group together and make a presentation, maybe on the next update on where this process is going. Because I'm just concerned that at a branch level, this isn't that important to 80% of the people in the room.
Yeah, I think it's a fair point. And look, you're right. Like, there was probably over 100 people on the call for the majority of the call. So and someone else made the exact point that we would have made to Department of Housing and Finance the last day. The quantum of farmers caught up on this is irrelevant. It's the significant economic impact of impacted farmers is what's the penal nature, and is just fundamentally wrong, certainly from our perspective. And look, you're 100% right in terms of that offer certainly has been made in terms of Gowran Park, and it's certainly something that we considered even in terms of this meeting here today. And certainly something that we'll keep under consideration going forward. But maybe the establishment of a kind of national group or a kind of collective, because as what James said earlier on, no matter what form of engagement you have on this zone land tax, someone has a little piece or nugget that someone else hasn't thought of or brought to the table that maybe be the missing pieces of jigsaw that we need maybe to crack the nut. So certainly it's something that I'd imagine we consider and maybe look to progress as the case may be down the road. So thanks very much for the suggestion.
Yeah, just Shane, just one last point there. Like, we worked very tough on the vacant site levy in Kilkenny, and we beat the vacant site levy, and we worked with Alan Navertrell in Cork, and we beat it there, and he won his judicial review. So look, we're available to give the benefit of our experience, and if there was to be some kind of a committee put together, I think there's nothing like having skin in the game. If the people, and it's no disrespect to yourselves, but if the people at the top table are directly affected by these issues, I think they might they'll stay till 2 and 3 in the morning at these meetings to make sure.
I get you. And look, in fairness to yourselves in Kilkenny, you've been very good in terms of sharing your knowledge and insight in everything to date. I suppose our consideration, even in terms of the logistics, in terms of having a meeting like this, there's people there from Carndonagh, there's people there from the far south of Kerry, and everyone impacted. And look, we just want to. That's fundamentally why we had an online meeting today, calling a spade a spade. It was just to allow people tune in online rather than having to travel significant distance on it. So, but look at it, I'm not discounting the need for an in-person meeting or a national group in the short to medium term. But I suppose that's just where we are at this point in time. But it's certainly something that we consider, and we will certainly leverage off the experience and insights that you guys have.
Thanks, Alex. We've got John Nolan looking to come back in again. Can you hear me there, John? John might be able to hear me. Yeah, maybe Michael Upton is waiting to come in as well.
Yeah, just to make a point following on what Alex said, you know, if we can somehow coordinate the lobbying of TDs and ministers and make sure they're all getting covered, that might be useful just to keep the profile right up there, which I know is a key objective that has been identified.
Yes, Michael, definitely. And that's where I think we do need to put the pressure on. We need to put the pressure on at a lot of different angles in the meetings that we have with the department, but also on all the TDs, that they have to realise at this stage that, you know, the top level answer they were given at the time, that when they were being lobbied, that farmers could de-zone and the option was there for them, that hasn't materialised, and they need to understand the consequences of that to farm families. And we need to be able to drive the message home. Anybody else there with a hand up?
I don't know if John's come through, but I've got a specific question maybe here that James can comment on. It came through in the chat earlier from Leo. It's if more than one person owns the land stroke site affected, how do they make the submission? I guess the appeal maybe in Bord Pleanála, is it just in a joint name, I guess, or would you have any technicalities around that, James? Yeah, sorry, you're on mute, James there. Yeah.
Sorry, Karol. Ideally, if there are two people on the folio, they should both make the application. In the alternative, someone can give a letter consenting to the application be made, or someone, even to get it out of the traps, someone should consider making the appeal, but saying they're doing it on behalf of the registered owners. But that being said, even if there's a dispute between, say, a father and a son or whatever, and one part, they still have an interest in the land, they can still object to it. Because their interest in the land, they have we'd say a half share of their interest in the land has been affected by this, and they will have a liability for the tax, even if the other party isn't that pushed about it, if that was to be the case. So one person can make it. Ideally, all the owners of the folio should do it, but certainly one person can do it in their own right.
Very good. I think that's all the questions, Rosemary, we have at the moment. That's everybody covered.
Rosemary, can I ask a question, and might be a little bit out left field, just for the people on the call and for the benefit maybe of those that are still to make their submission, from engagements either with other farmers who made a submission or even yourself, anyone that has been successful, on what kind of grounds have anyone heard of that got them over the line? Certainly from anything that I have heard is primarily being around access. And the challenge in terms of accessibility in terms of sites has got people over the line. So whether someone wants to take the floor, if they have direct experience themselves, or throw it in the chat, it just would be interesting in terms of, you know, as I said, maybe some people that are still formulating their own submissions. I think Andy up in Donegal is there again.
Yes, this is Evelyn from Cardona again. No, Evelyn from Cardona. I just want to know, when I made my submission and I got a reply back from the County Council, they mentioned the water and the sewage and everything being near town. The one thing they didn't address, which was the most important thing, was my entrance. It was landlocking the development land. Yet they're sold me for tax. So how does that work out? I am landlocked from development, and I've opened the land behind. And the County Council themselves helped to create it. They helped to landlock the land themselves when went through the land, went through with the roadway. They didn't give us the entrance that we were supposed to get onto their own county development plan. They contravened their own county development plan when they went through with Innerleaf Road and left us with an unsafe entrance for farming. And now they're coming back now to tax me on the land that I have. So I don't understand that.
Get on that,
and I don't understand how the senior planner can ignore the entrance and talk about everything else. And I wrote a letter back to him asking him, told him that the thing wasn't clear on his assessment of my property, that he would need to address the entrance because I have landlocked land that I can't develop. and it shouldn't be taxed on. I'm sorry, that's about all I could say. Is that okay?
You get all that, Rosemary?
Yeah, we've got that there.
So basically, the Donegal County Council have caused Evelyn's land to be landlocked because they didn't follow their development plan for leaving an entrance of 20 metres. And Evelyn has a letter back from a couple of years ago where the council have admitted that they have actually landlocked her land, but they still won't remove it from the tax. Maybe James might be able to answer something on that.
Well, I mean, I was listening to the queries there before, so it's obviously quite a complex issue there. But I think that might be part of whether the land should be zoned for tax or so it's liable for tax if it doesn't have access, if it's landlocked and doesn't have access out onto roads or inappropriate entrances onto roads. That may be one of the reasons that is not suitable. And again, you just have to put that in and appeal it, and ultimately Board Pinola will decide it.
Anybody else there, Karol, with a hand up?
Yeah, we've got Seamus Doherty. You can unmute yourself there, Seamus, maybe. Sorry, it's not coming through there from Seamus. I have one other query here in the chat, maybe again for you, James. It's from Michael Dolan. Farm residents and sheds surrounded by 3 or 4 acres. The rest of the farm is elsewhere. It's not bounding that piece of land. Can there be a case made that the 3 or 4 acres will be exempt as there's no limit on the size of a garden in the legislation?
Yeah, I saw that query. So the revenue for general purposes will take a house and a garden that they will kind of, when you're looking at, say, a private principal residence, they will consider a garden up to 1 acre to be part of the private principal residence. So I think each case will have to be determined on its own merits as to whether or not that is part of the garden, or whether, you know, whether it is a garden part of the house or is it outside it. And you know, there can be grey areas there, because, you know, when is an orchard which maybe runs out from a garden, is that part of it? But if it's a separate paddock or a field, I think there might be a problem with that. But, you know, the revenue would take a view that a general garden would be up to 1 acre unless you can really show otherwise.
Thanks, James. Yeah, unless James can come in, which I don't think he can. I think that's it now, Rosemary, at the moment.
Okay. We're nearly at what, 10 to 1. So I think we've had a very good session. A lot of concerns, a lot of points made. And I suppose another thing I've noticed with all the ministers that we have lobbied, they're constantly asking us for details from farmers, a database, that, you know, information on who's affected and who didn't get their appeal, or who didn't, you know, get the answer that they were looking for, because I think they were inclined to think that there wouldn't be many farmers affected by this. So if people are happy, we're trying to build a database of farmers that are impacted by this, and all of this will strengthen our arm in the negotiations that we're having in the meeting level and politically. So if people are happy, that if they could send their situation or their information, or send an email in to us, that we'll be able to build a database of the amount of farmers that are affected by this, and that will strengthen our case. And in any correspondence that we would have, no names will be mentioned, they'll be anonymized, but just we'll have more strength and more armour behind us when we're trying to make a case at a political level that there are farmers impacted by this, farm families, actively farmed lands. And as we said earlier, the department know, I mean, your herd number, your BPS, all the detail behind us. So I suppose in summary, thank you very much for logging in. Thank you very much for all your attention and your interaction with us. And if we will push this as hard as we possibly can. we'll watch and see what An Bord Pleanála do with the a step back to make sure that anybody that wants to put in their appeal to An Bord Pleanála, you have to engage with the system, as has been said there by all of the speakers and especially by James, that you have to interact with the system and go with the process and the guidance that's there. And you have to put the your appeal into An Bord Pleanála. We'll see then what An Bord Pleanála do. From a political point of view, we'll put as much pressure on as is possible. Hopefully there will be, some changes or something will happen. And I think we'll call it an end at that point, unless Karol or Shane or James wants to say a final few words in closing.
I'm happy anyway. I think we've covered everything there, unless one of the other two guys have anything to add.
No, Karol, I'm happy with that. So
the only thing I suppose is, yeah, exactly, and look, it's been a good constructive meeting. I suppose the meeting itself and the slides will be put up on the website later on for anyone, and again you can share with any other people that maybe have not been able to join today. And as Karol alluded to in the chat there, if you are impacted or someone associated impact and you want to Rosemary's point, maybe send in a little bit of information on it, you could send it into info@ifa.ie. So other than that, thanks very much. And as I said, we'll keep up the good fight.
And sorry, before you leave, there was just one last question just coming here in the chat, and it's from Donald Dempsey. Is land coloured on the residential zone land tax map, but described as existing residential rather than new residential, also within the scope of the tax?
I'd say the short answer is yes. Anything that's zoned yellow is zoned residential and in scope. If it's red, you have the grounds under the mixed use to maybe challenge the inclusion, and certainly anything that's yellow is included.
Great, so
thanks very much.
Thank you.
Okay, thanks very much, everybody. Thank you.
Thank you.
Take care.